Hello and welcome everyone to another live edition of Employment Law Q&A. My name is Alex Lucifero. I'm an employment lawyer and partner with the employment lawyers Samfiru, Tumarkin, LLP. If you're tuning in right now in Canada and you're in the provinces of Ontario, British Columbia, or Alberta, this is the time, this is the place to go ahead and post your questions, speak directly with an employment lawyer, and get those workplace issues and conflicts resolved, or at the very least, on the road to resolution. Again, this is a live employment law Q&A. We are here to take any and all questions, if you're just tuning in, with respect to really any issues dealing with your work. If you're dealing with a situation at work and maybe you aren't getting along with a particular colleague or with a manager or supervisor, maybe your employer is asking you to accept certain changes to your job. Maybe they're asking you to accept changes to your schedule, or changes to your compensation structure, or changes to your position, or certainly, if your employer has temporarily laid you off or has let you go, has terminated your employment. Any of those situations are quite severe. They're quite serious, and you need someone in your corner to provide proper advice, proper guidance on how to solve those kinds of situations. Really important to keep in mind, across Canada, employees have a tremendous amount of rights and protections in the world of the workplace, in employment law. But of course, if you don't know what those rights are, if you don't know what options you may have as an employee dealing with a difficult situation at work, well, then you're not going to know what option is your best option and what the solution is to your difficult situation. So you need to know the way the law works. Certainly, you need to know what options you have in any given circumstance. And then you need someone to guide you through that process. That is what we do as employment lawyers every single day. We are on the phone with employees every single day, giving advice, solving problems, helping resolve people's workplace problems and disputes. Before I get into what we call, at least on our radio show, the case of the day, it's an opportunity to talk about a matter that came across my desk this week that I think is a good lesson for lots of employees out there. Wanted to share our contact information first and foremost. And where we should probably start is our website. Employmentlawyer.ca is the first place you should go after this live stream. For our contact information, of course, you can find information about us on our website. But we've also got a ton of resources, whether those be articles. We have essential guides for employees and employers to just understand your basic rights in any given circumstance. We also have a ton of news articles and videos that you can view as well. If you want to reach out to us directly, very easy to do so. help@employmentlawyer.ca is the email address. help@employmentlawyer.ca. Go ahead and send us a brief email. Tell us about your situation. Don't send us a 30-page document, but give us a couple of paragraphs on the situation that you're dealing with. Maybe you've been let go from your job and you've been offered severance. Maybe you're dealing with a temporary layoff, or maybe your employer's mistreating you somehow. Give us a brief description. Please go ahead and contact us at help@employmentlawyer.ca, and I guarantee you someone will get back to you. Of course, if you're like me and you like to kick it old school a little bit, give us a call at the office. Our number's on our website. You can certainly reach any one of our offices, and we certainly have an entire intake team standing by, ready to answer calls or call people back and assess the situation and put you in touch with an employment lawyer. Please do not be shy to reach out. There are no bad questions when it comes to employment law. If you're feeling like you're stuck at work, if you feel like you are dealing with a difficult situation, it's causing you stress, it's causing you sleepless nights, you don't know what to do, there is a solution, there is an answer, but you need professional advice. Like in any other walk of life, you need professional advice, and who you want to reach out to there is an employment lawyer. Case in point, everyone, let me talk about a matter that came across my desk earlier this week. For those of you just tuning in a couple of minutes in, you haven't missed all that much. Again, this is an employment law Q&A. It's a live a show where you can go ahead and post your question on whatever platform you're viewing this on, and I promise I will get to your question before the end of the segment. To get the ball rolling here, spoke to a gentleman earlier this week that was in quite a difficult situation. Long service employee. This gentleman has been working for an automotive dealership. He's a mechanic. He's been working for an automotive dealership for the past 25 years. He's very good at what he does, very experienced at what he does. He's in his late 50s. This is effectively his entire career. He's a front end mechanic. Essentially, he works for a particular dealership, particular car company, and all he does is front end stuff, and he's very good at it. Well, lo and behold, just about a week or so ago, his employer, the car dealership, comes to him and says, as of January 1st next year, so in several weeks' time, we're going to be changing your position. You're no longer going to be simply a front end mechanic. You are going to be assigned really any and all work that our mechanics do. So if the job that comes in is a change of tires, or if the job that comes in has something that doesn't have to do with the front end, but is related to anything else for that matter, we're just assigning work on the fly, regardless of your expertise, regardless of your history with the company, and regardless of your specialty. And on the face of it, you think, okay, well, maybe not a big deal. A mechanic's a mechanic, right? But that's not the case, it turns out. This gentleman was so specialized in the work that he did, and he did it so well and did it so efficiently that he made quite a very good income from doing his specialty. And the company's change by him, changing from a front end mechanic to doing anything and everything that has to do with a car, that was going to result in a drop of income, or a drop in income for him. And it's going to have a pretty dramatic effect on his income. He told me he estimated, this hasn't happened yet, so it is an estimate only, but he estimated that he's going to probably be losing about $20,000 a year in salary as a result of this change. And so while on the face of it, the change in this employee's roles and responsibilities isn't tremendous. He's still going to be a mechanic. He's still going to be working on cars. He might not be only working on front end repairs and mechanics. He might be working on all sorts of issues as well. And again, to a layperson, that might not be a major change, but that is going to have a dramatic change on his compensation. And that triggers protections for employees in the world of employment law. You don't have to accept a change to your employment that is going to affect you in a negative way. Lots of employees don't realize this. Lots of employees think and are primed and trained effectively to think that whatever my employer says, I've got to do. And if it means that I'm going to be earning less, or if it means that I'm going to be changing roles or changing job responsibilities, I guess they have that right. I guess employers have that right. No, not necessarily. Not if that means losing the main functions of what your job was for your entire career. Not if it means a significant drop in your compensation as a result of those changes to your job responsibilities. That is what we call in the world of employment law a constructive dismissal. For those of you that have been watching the live streams and listening to our radio shows and watching our TV shows, you will know what a constructive dismissal is. A constructive dismissal is a major change to the terms of your employment, where you as the employee have the right to say, no, I'm not accepting that change. That's too major a change. You're changing the terms of employment here in too significant a way. And you would be allowed at that point in time to treat your employment as terminated. It's effectively a breach of contract situation, and get your severance entitlements and get moving on with your life. In other words, your employer is not formally terminating you by handing you over a termination letter. It's not that straightforward a situation, but rather through the company's actions, through them changing this gentleman's job responsibilities and impacting his compensation by probably somewhere in the range of $20,000 a year, which, by the way, almost no one could afford nowadays. That's a massive pay cut. that is a constructive dismissal. The employer is triggering a breach of contract situation. This employee, if the company doesn't back down, he's going to be allowed to say, you know what? I'm not accepting this change. I want my severance entitlements. I want them now, and I'm going to be moving on to bigger and better things, hopefully. By the way, this individual's severance entitlements with 25 years of service, he's in his late 50s, he was in a very specialized role. His severance entitlements are going to be 2 years of pay, 24 months of pay. Severance is based on an employee's age, position, and years of service. The older you are, the longer you've been with the same company, and the more specialized, or certainly the more senior your position is, the more severance you're going to be entitled to. Employees with 25 plus years of service who are getting up there in age and specialize their management level positions, they're going to be looking at the maximum, which is generally right around 24 months of pay, not weeks. This gentleman is looking at 2 weeks of pay, or 2 years rather of pay, if he's constructively dismissed. That's what's at stake here. It's a serious situation. We are going to be helping this individual through this situation. Hopefully the company backs down, and this man can continue his career, retire with the company, and continue earning the very good earning that he's living as a front-end mechanic. If the employer doesn't back down, he will be owed severance, and that's going to be significant for this gentleman as well. It's going to be hundreds and hundreds of thousands of dollars based on what he's earning. Nothing to scoff at. For those of you, even if you're short service employees, even if you're, in your 30s or in your 40s, and you might not think that your severance entitlements are all that significant, guess again. Severance is significant. Severance could be several months, even for 1-year employees or 2-year employees. Don't think that your severance entitlements are just a couple of weeks of pay or a week per year of service, which is another myth that we often have to dispel. Severance could be months and months and months, even if you're a short service employee. And if you're a long service employee, it could be as much as 2 years of pay. Hopefully that helps. Hopefully it helps set the scene, guys. We deal with constructive dismissals all the time. Be very wary of your employer trying to change the terms of your employment. If they approach you with a responsibility change or a job duties change, if they approach you with a temporary layoff or with a change to your schedule, that should be setting off a bit of an alarm bell in your mind to say, this is a negative change. I may be able to dispute this. I don't necessarily have to say yes to everything my employer says. Before, however, you tell your employer no, before you mention or even utter the words constructive dismissal to your employer, do yourself a favor and do us a favor for that matter. Give us a call. Let's have a chat about it. Lots of the consultations we do are free of charge as well, by the way. Not all, but lots. And so if you want to have a chat, strategize about the situation, we're available to help. Do not be shy to reach out to us. Go to employmentlawyer.ca. Reach out to us at help@employmentlawyer.ca by email. Give us a call at the office. We're more than happy to chat always. Thank you so much for allowing me to go into that story a little bit. It legitimately happened earlier this week, and it's why I wanted to talk about it today. But we are here to answer your questions. We are here to help in real time resolve whatever employment issue you are dealing with. So if you are just tuning in, again, my name is Alex Lucifero. I'm an employment lawyer. I'm a partner with Samfiru, Tumarkin, LLP. We are the employment lawyers, certainly in the provinces of Alberta, British Columbia, and Ontario. If you're in those provinces in Canada and you're dealing with an employment issue, number one, post your question right now. I promise I will get you on the road to resolving it. And secondly, and more importantly, give us a call at the office. Let's have a chat off air and talk in length and in detail about your situation, and we will be able to resolve your workplace situations. And even in a situation where we can't resolve it perfectly, a difficult situation, you should at least know what your options are. And even if it's a difficult option that you ultimately have to accept rather, at least you've done your due diligence. At least you know now the way the law works, what options you have, and what your best option is in the circumstances. All right, everyone, let's start with the questions here. First in line from our Facebook stream is Linda. Linda asks, can an employer terminate an employee within a 3-month probation after the employee has filed a harassment report. Linda, a couple of competing issues here. So, number one, and probably most importantly, an employer cannot, and I repeat, cannot terminate an employee in response to a harassment claim. That they cannot punish, even if the harassment claim ultimately is unfounded, by the way. An employer cannot punish an employee for filing a harassment complaint. That is what we call in employment law a reprisal. A reprisal is effectively what I just explained, when an employee is punished for having exercised their rights under the law. Submitting or filing, even if it's just an email, by the way, even if it's a meeting or a conversation, voicing concerns about harassment in the workplace is an inherent right that all employees have. In Ontario, it is a right and a protection governed by the Occupational Health and Safety Act. The Occupational Health and Safety Act also provides that if an employee is punished as a result of voicing those kinds of concerns, by the way, they could be concerns about health and safety in the workplace as well, that is a reprisal. It is illegal, plain and simple. So, Linda, to answer your question straightforwardly, if your employer let you go because you filed a harassment complaint, that is a reprisal. I do not care, and it does not matter at law whether you are in a probationary period or not. It's still illegal. An employer can be punished quite severely for breaching, again, in Ontario, the Occupational Health and Safety Act. There could be bad faith damages awarded to employees in those circumstances. And certainly, even as a 3-month employee or 2-month employee, there would be some severance owing there as well. Now, apart from that issue, Linda, quite interestingly, employees in a probationary period, it always comes up whether these employees are owed severance or not. If I'm in probation, am I still owed severance? If I'm just new to my job, am I still owed severance if it's been less than 3 months? Keep in mind, everyone, probationary periods have to be contractual, meaning they have to be written into an offer letter or an employment contract that you've signed with your employer, and that is a term of employment that is in black and white. Probationary periods aren't implicit, they're not silent. If you accept a job offer or sign an employment contract or shake your employer's hand and start working, and there is no probationary period in black and white in writing, then a probationary period does not exist. It's not a term of your employment. Even if you're let go within the first 90 days, within the first 3 months, you would still be owed severance based on your age, position, and years of service. And as I was saying just a couple of minutes ago, even employees that are a couple of months into new employment can still be owed months of severance. I had an experience not too long ago, actually, where a 7-month employee was ultimately awarded 4 months of severance as that employee's severance entitlements. Again, we're not talking about a couple of weeks here for a 7-month employee, less than a year, pretty much half a year employee got 4 months of severance. That's how significant your severance entitlements could be. If there is a probationary period in your employment contract, do pay close attention to it. Your employer can potentially let you go with very little or even with no severance if you're let go within that 3-month probationary period. But again, it has to be in writing. A great tool that we will recommend our listeners and viewers and clients as well will use is the Pocket Employment Lawyer. PocketEmploymentLawyer.ca is the website. It's right on the screen right now if you want to have a quick look. It is a great tool, actually, for a couple of different things. Number one, it can assess a constructive dismissal situations, answer a couple of questions, and you'll get a sense of whether you're dealing with a constructive dismissal or not. It can also calculate your severance entitlements. There's a severance calculator there that's worked into the Pocket Employment Lawyer, where you can input your age, position, and years of service, and then get a rough sense of what your severance entitlements would be based on those factors. If you're wondering about any of this, maybe you're too shy to post a question right now, maybe you're too shy to give us a call at the office. And by the way, please don't be. Please feel free to reach out. We're always happy to have a chat. But as a starting point, go to pocketemploymentlawyer.ca, answer a couple of questions. It's completely anonymous, it's completely free, and you will get a better sense, certainly, of where you stand when it comes to your employment rights. All right, next in line. And by the way, please keep posting your questions. We've got another 10 minutes here on the live stream. And now is the time. You're speaking with an employment lawyer. Do not be shy. You don't have to go into any confidential information. Don't tell me your employer's name. Don't go into specifics. Ask a general question. I promise you will feel better knowing the answer to that question rather than not. Next in line is Yusuf. Yusuf asks, I have two insurer LTD. If I get severance paid, does apply for both insurer. Thank you. Both is different jobs. Yusuf, I think I understand your question. If you are receiving severance, it is important to keep in mind that there is likely some sort of set-off between disability benefits. Yusuf mentioned LTD. LTD is long-term disability. There is potentially a set-off there, Yusuf, between what the amounts of money you receive as severance and what you are receiving as disability insurance. Certainly, if you receive a severance amount, the insurer is going to want credit for that, meaning you cannot double recover both disability insurance and severance, which is employment income essentially. There's going to be a set off there. The insurer will probably temporarily, for whatever period of time the severance represents in terms of number of weeks or number of months, they are going to reduce their payment in disability insurance based on what you received as severance. That is a very common, quite frankly, I've never not seen it, term in any disability insurance policy. Any other income that you might earn as someone that's receiving disability benefits, maybe not any, but lots of, and especially employment income that you earn as an individual that's receiving disability insurance, those other amounts will be deducted from what you are receiving as disability insurance. Yusuf, here's the good news. Not only do we practice employment law here at Samfiru, Tumarkin LLP, we are also experts in disability insurance as well. And if you are dealing with a situation where on the one hand you're dealing with severance and on the other you're dealing with disability insurance, please give us a call. Please reach out to us. Help at Disability Rights is actually the email address that you can reach us at. help@disabilityrights.ca is the full address. Go ahead and send us an email. Yusuf, describe your situation in more detail, or again, give us a call at the office. Happy to have a chat. We have plenty of specialized lawyers that assist in both employment insurance and disability insurance, and that can help you navigate those waters. And they could be tricky waters, Yusuf, because again, you're dealing with kind of two different entities here, your employer and the insurance company. And while it's easy perhaps to think of those two as one of the same, they're actually different, and different rules apply, and the law potentially works in different ways if we're dealing with an insurance company and an insurance policy as opposed to an employer and whatever employment rights you may have, particularly when it comes to severance. So give us a call. Please reach out, Yusuf. It sounds like a situation where you're going to need some guidance and need some advice. Letitia on Facebook is up next in line. Letitia asks, let's see here, can an employer refuse to pay earned commissions if you've resigned? My commission structure is part of my contract and is paid out monthly, but now they are refusing to pay my last commissions after I gave notice. Great question, Letitia, and an important one at that. The answer is no, they cannot refuse your commissions, despite the fact that you've given notice of resignation. If you have worked and have earned those commissions, Letitia, those are earned wages. It does not get any simpler than this in the world of employment law. If you have worked for whatever earnings you are due to receive, your employer owes you them no matter what. And so if you've done every single thing that you had to do, Letitia, to earn those commissions, if you're a salesperson and you've closed the sales and the business is done and the work is performed and you're just waiting on the money and you have since resigned, those are earned wages. It's as if you put the hours in, and no matter if you then left the company, you are still owed for your time. In your case, when commissions are concerned, if you've put the work in and put the hours in, no matter what happens next, Letitia, you are owed that money. The good news for you, Letitia, is if your employer continues to refuse, these are very easy situations to resolve. They can often be resolved with a phone call from an employment lawyer, such as ourselves, or even a letter, perhaps more sternly, oftentimes an employer will pay immediately after they know that we're involved. The Ministry of Labor may also be able to assist here. If you're in Ontario, Letitia, when it comes to earned wages, the Ministry of Labor can be quite a useful tool. Now, having said that, I should also add the Ministry of Labor in Ontario, and this will apply to British Columbia and Alberta as well, oftentimes, if not always, the wrong place to go when it comes to your severance entitlements. There are exceptions to this rule, to be clear, but almost always, if you are dealing with severance, if you've been let go from your job and you've been offered a severance package, or maybe you've been let go from your job and your employer is alleging misconduct or alleging performance issues, and you haven't been offered any kind of severance, please do not go to the Ministry of Labor. It is almost certainly the wrong place to go. You need to speak to an employment lawyer. And the reason why that is that the Ministry of Labor in Ontario cannot enforce your full severance entitlements based on your age, position, and years of service. They can only enforce your minimum severance entitlements under employment legislation. And those minimum entitlements are probably a fraction of the full severance that you're actually owed. So when it comes to severance, Ministry of Labor is the wrong place to go. When it comes to things like temporary layoffs or constructive dismissals, wrong place to go. You don't want to go to the Ministry of Labor for those issues. If we're talking about overtime pay or vacation pay, or like Letitia's case, earned wages, Ministry of Labor might be an option. But still, speak with an employment lawyer beforehand, and we'll be able to tell you whether or not you should be filing a claim with the Ministry of Labor. Letitia, again, if your employer doesn't back down and pay you here, reach out to us. I guarantee you we can resolve that situation very easily. All right, a couple of minutes left. We're going to go through all of these and get them all answered, everyone. So we may even go a couple of minutes over time here. Lee asks, I'm part of the Fed Public Service and my LTD was denied. There are 2 appeals to Sun Life, then a joint employer Sun Life panel can do a 3rd appeal. Do I need to exhaust these appeals first? Lee, absolutely not. I hate to say it. I say it begrudgingly. Appeals are typically a waste of time. If you have your doctor's support and your doctor is saying you can't work, but you're still being denied LTD anyway, you can appeal once, you can appeal twice, you can appeal a 3rd time. Oftentimes, you are going to be left unhappy with the result there. Do yourself a favor, give us a call, speak to one of our disability insurance lawyers. We will set the record straight for you. And oftentimes, your best bet is to hire a disability insurance lawyer. By the way, we don't get paid on these disability insurance files unless we can actually resolve the situation for you. And so there's some security there, knowing that if nothing comes of this, there won't be any out-of-pocket fees. But alternatively, please don't continue with the appeal process. Make sure you get employment or disability insurance law advice from one of our disability insurance lawyers. You saw the email address on the screen just a couple of seconds ago, help@disabilityrights.ca. Please reach out. Lee, I would not recommend another appeal. R. Morris, asks, should I file a complaint with the ministry for or against a taxi company misclassification and health and safety issue? R. Morris, if you're talking about kind of a misclassification in the sense of whether you're an employee or whether you're a contractor, perhaps, no, the Ministry of Labor isn't particularly useful in a situation like that. I mean, they can make those kinds of decisions, but the recourse that you have and whatever compensation you may be owed as a result is going to be very, very limited through a Ministry of Labor process. I would not recommend it, at least not recommend it without speaking to an employment lawyer first. This is kind of public record, so I can say it quite loudly and proudly. We are involved, a firm is involved in the Uber class action lawsuit, taking the position that Uber drivers are employees and not independent contractors. So we're well aware of these situations, Morris, and more than happy to chat with you about them. It is in our wheelhouse for sure. Steve is up next. Steve asks, my friend was just released from her contract 2 weeks early. She was employed, for about 1.5 years. Is she owed anything? Steve, depends on the specifics of the contract. If it was a fixed term contract and it was ending in 2 weeks, regardless, and undoubtedly, the extent of her entitlements may only be the balance of the contract. Those additional 2 weeks that she was let go early from. If these are, however, successive contracts, she's been signing these contracts year in and year out, or month in and month out, perhaps, she may be owed additional severance beyond those 2 weeks. The devil's going to be in the details. Steve, I know I'm starting to sound like a broken record here, but there's only one way to answer the question, and that's to review the contract, speak with your friend. If she hasn't already, or if you haven't suggested it to her already, please reach out to us. Let's have a chat off air. I'm happy to chat with her myself, or one of my colleagues for sure would be more than happy to chat with her and get that question answered. It is the right question to ask, and it needs an answer. You don't want to assume, you don't want to just walk away and then wonder one day, oh, maybe I was owed something more than that. Again, we're talking about thousands, if not tens of thousands of dollars here on these situations. And again, for longer service employees, it could be hundreds of thousands of dollars. Deb McKay asks, do you help people with small amounts owing to them? Absolutely, Deb. Big or small, we can absolutely help with these. You mentioned 3 or 4 months of pay. 4 months of pay is probably not a small amount of money. And by the way, we certainly have, a team. We're dozens now of employment lawyers across the country that help employees out in these situations. We also have a big team of paralegals that help with smaller claims and certainly small claim court legal action and the like. All right, last couple of questions here. Hugo, interesting name, asks, does the employer have the right to require an employee to call in sick 24 hours before their shift? Working in a small business, not indicated in my contract. Hugo, no, that sounds unreasonable. I mean, you can ultimately call in sick. It's not a guarantee that you'll know 24 hours beforehand whether you are able to work physically, medically, or not. And so that is an arbitrary rule. I would, obviously you want to be reasonable in the circumstances as an employee. You want to give your employer as much heads up as possible if you're dealing with a health issue, if you're dealing with a medical issue, and let them know as soon as possible. But 24 hours, there's nothing in the law that provides for that, Hugo. And so if you can't meet that deadline, you really shouldn't be punished for it. Ultimately, do the best that you can, but 24 hours is not a hard and fast rule, certainly. All right, last one for the day. Everyone, Scotty asks, here we are, worked for the same company for 19 years. Boss has talked about retiring, but has not. Last few years, my 40 hours a week have been cut to 0 to 40 due to economy and turning down jobs. What are my entitlements? If I get another job, do I lose whatever entitlements I could potentially have? Great questions, Scotty. So when you say your hours have been reduced from 0 to 40, it's obviously a very wide degree, very wide margin. If your hours have been cut just by a couple of hours a week, that might not be a constructive dismissal. It might not be actionable in that sense. If your hours are reduced, I would say anywhere between 5 and 10 hours per week on a regular basis, yeah, that is probably a constructive dismissal, and you would have recourse there. And to answer the second part of your question, yes, severance is also based on an employee's employability and their job prospects. So if you bounce back into a new job immediately, that might impact your severance entitlements, at least to a degree. And not entirely. You're not going to be owed 0 as severance, Scotty, but you would certainly have to take a bit of a hit if you find the job right away. Regardless of that issue, Scotty, if you're a 19-year employee, your severance entitlements are potentially significant. They can be anywhere between 18 months and 24 months of pay. And so this is a crucial issue. It's an important issue. Regardless of how much your hours have changed, regardless of what your boss is or isn't doing right now, or how the company is doing right now, do yourself a favor, get informed. It's been the theme of the show today, everyone, and we will wrap it up on this. Get informed on what your employment rights are, on what your options are, so that when something happens, or if something happens, you know what to do in the moment. You know how to respond. Again, you know what options you have. You want to arm yourself with the knowledge and the experience that we as employment lawyers have, so that you're ready for whatever comes at you in your workplace. We will leave it at that, everyone. Thank you so much for the questions. There were some great ones this week. Tune in for our next show. We've got one of these pretty much every day of the week. Until next time, everyone, have yourselves a great rest of the week. And until next time, so long.